I want to welcome everyone who's joined us tonight. Thank you so much for joining our town hall on California meal and rest breaks and the case of Bernstein versus Virgin America. We have a lot of misinformation out there from management, and it's really important that we answer all of your questions because the airline industry on the whole has been putting forward a sky is falling narrative about the decision by the court to uphold California law as it is applicable to flight attendants. So we're going to get into this town hall. We have with us our legal experts to help us through this process so that we can understand all of it. Joe Burns is our AFA General Counsel and Director of Collective Bargaining. And John Morse is our Associate General Counsel and works a lot on our litigation and also supporting our efforts around legislations. So we have two experts with us here who can help to answer all of the questions and lay this out for us. I want you to know that this issue around the California meal and rest breaks that the airlines are talking about and threatening that not only is the sky falling, but the flight attendants should be very concerned because enforcing the California meal and rest break law will cause them to close down California bases. And we find that extremely hard to believe. We also are going to talk about why they're pushing this so hard and how it relates to their efforts to push preemption. I'm going to have Joe Burns describe what preemption is, but this is an effort to deny us rights that are benefits that are in state law that are better than federal rights. They want to deny us this right across the country, and they believe that this case is their best narrative for convincing flight attendants to say, yes, please, we didn't ask for any of these rights. We don't want them. Take them away. That's what they're trying to inspire here. That is not where we need to get to. And we need your help to push back and say, talk to our union. Because just like contract bargaining, we have the ability to resolve issues, make sure that our rights are preserved, and make sure that the operation can operate. There's no way that we are going to stand by while airlines would just close bases. And frankly, it's a threat that we should all find offensive. And we want you to understand it's completely unnecessary because there's a very simple solution that we can get to. But they are absolutely trying to terrify people and get flight attendants to say, I want to give up my rights, and get the public to believe that this is an issue that is so onerous to the airlines that it could make the industry collapse. And they want to make lawmakers believe that they need to preempt our rights everywhere. So we have several fights across the country to uphold standards that are above the federal law that flight attendants count on to be able to take care of their families and actually get what they need as human beings. So I'm going to turn it over to our general counsel, Joe Burns, to explain what preemption is. Before I do that, I just want to note that in the last FAA reauthorization bill, this is something that management tried to sneak into the bill at the last minute. They were unsuccessful in doing that because we had been working for 4 years on that legislation and lawmakers didn't put up with it because of that. But they are trying to set the stage for this next year with the FAA reauthorization bill to make this law and to preempt our rights all across the country. So this is a very serious issue that we need to understand now with the specifics around the California meal and rest breaks, but it's also a very serious issue going forward about protecting our rights in general. Joe?
Good afternoon, everybody. So I'm going to talk to you a little bit to start with about what is preemption and why does it matter for workers and in particular flight attendants. And I'm going to talk a little bit about what is the sort of general theory and legal theory on preemption, and a little bit about Bernstein. And then I'm going to hand it over to John Morse, who's our Associate General Counsel, who's going to go into detail on Bernstein and some of these other cases as he's been actively overseeing the area for our union and our legal department. So preemption comes up in general as related to workers because There's many areas where Congress has not enacted what we would consider to be adequate worker protection. And what unions have done is they have gone to their state's legislature, the workers and unions in those states, and in particular, certain states like California and Washington State, and they have got their state legislatures to enact legislation that's favorable to the workers in that state. And this legislation, generally speaking, applies to all corporations who are working in the state. So if you're Walmart, even though you have a national corporation, you're required to know what the laws are in California and comply with those laws for your workers. Ford Motor, 7-Eleven, I don't care what sort of employer you are, employers know this, and they have to have a legal department and a human resources department that understands and applies these laws. And in particular for the airline industry, we have a lot of laws in certain states that are beneficial to our flight attendants. In California in particular, we've got the pandemic care leave where folks are able to still get paid and pay protected for COVID, which everyone should get, but they have it in California. We have it in California. We have sick leave protections. And at issue here in this particular case, they have specific provisions on meal and rest breaks. So what employers have done across the country is they've turned to this legal doctrine called preemption. And, in general, it relates to the issue of, if Congress passes a law in an area, does that take precedent over the state law, and in what situations? So employers have been very, very aggressive about arguing this issue of preemption because they want to throw out any airline employers in particular, any law that's beneficial to workers and flight attendants and other airline employees. So they want to get rid of it. And they've been very aggressive around the country. And we've had a lot of fights and private lawyers have been, flight attendants have been, having private lawyers and states taking on the airlines because they don't believe that any of these protections should apply to airline workers. Even though other industries, they supply these protections. So the preemption, strictly speaking, is, and it's different by the federal statute, and John can talk about that a little bit. But they'll argue preemption under the Railway Labor Act. They'll argue preemption under the Airline Deregulation Act of 1978. They'll argue preemption under ERISA, which is a federal pension law. And they'll basically argue under these that the specific state law should not be applied to airline workers because Congress has passed this other legislation or protections here. And in particular, one of the flashpoints that we're going to talk about is the Bernstein case, which involves meal and rest provisions and employers aggressively arguing that shouldn't apply to airline workers. There's extensive litigation that, where they tried recently to go to the Supreme Court on the issue. And, the bottom line is, I think we as a union, take the position that airline workers should not be second-class citizens in this country and should be afforded basic protections. I think as, Sarah will talk about, and I'm sure we'll get into a little bit more, there's certain areas where we're a unique industry. And there's situations where they need to, come and sit down with the union. In California, there's a long history of unions and employers doing special, accommodations for their industry where the workers get protection. But they're not completely denied them. They just adapted to the situation. So here, there's a dispute going on about the applicability of these laws. And I think it would be beneficial if John could walk through some of the specific cases.
Thanks, Joe. Good afternoon, everyone. So Bernstein is the main case that we're talking about, but there are a number of cases that are involved here. But Bernstein involved, is a class action lawsuit that involved California-based flight attendants, as well as a subgroup of California flight attendants who also live in the state. The Court of Appeals ultimately ruled that the California meal and rest breaks applied to them because they live and work in California. But there are several statutes that are also at issue that the airlines are challenging across the board. For instance, there's separate litigation from this that involves the wage statements that California provides. There's a case called Ward versus United Airlines that speaks about that. And in that case, they talked about, pretty minimal standards that airlines have to abide by in terms of simply ensuring that the airlines tell you when they're paying you and how much they're paying you at what rate. So pretty basic things that airlines still aren't, that some airlines still aren't abiding by. Washington State has seen, I think, some of the most extensive litigation when it comes to preemption. And there are several statutes in Washington that Alaska Airlines in particular has been challenging over the years. Things that would not be very burdensome for them to comply with, things like taking care of the elderly when they are getting ready to retire. There's a state provision on providing an additional amount of funds for them for that. Alaska's challenging everything instead of seeking ways to comply with the statute. There are state sick leave statutes that the airlines are also not complying with that are at issue here in New York, Massachusetts, and Washington State as well. So all of that.
And John, I just want to make clear to people, in terms of sick leave, these are things like assuring a set number of accrual hours, assuring that people can take and use that sick leave to care for themselves and potentially for family members without fear of discipline. These are the kinds of laws that have been passed in these states.
Exactly. And this is nothing new either. So if we go back to California for a moment, the wage statement law at issue, for instance, that Alaska and United and other carriers have said that is preempted and have lost on this issue. The wage statement law has been around since 1943, and it was expressly created for transportation workers engaged in interstate commerce. So this is nothing new for all of them, for the airlines. And surely they knew about this all along. Talking about another case too, there's a case involving JetBlue. And so, the reason why we know that management claims are just outlandish is when we look at this JetBlue case, for instance, we had, this JetBlue New York corporation that has flight attendants flying into California. They were connecting between different airports in California, and they tried to argue that California law applied to them in between airports. They lost that case because that wasn't applicable to the California area. And so it's not nearly as broad as the airlines are saying the impact would be. And so this is a very, I think, limited application of everything is I think what we want to make clear for all of you.
And John, can you just go back and just describe what the California meal and rest break provisions are that are provided for? This is really about just making sure that people can get something to eat during the course of a day, and not fear discipline for actually taking the time to eat.
Right, and it's again very basic. I think a very basic principle and should be easy for airlines to abide by. We're talking about every 5 hours you get a 30-minute break to eat. We're talking about I think it's like 10 minutes every so often for the rest breaks. I mean, it's very 10 or 15 minutes. It's very minimal every so often. But after you've been at work for a certain amount of time, that you're entitled to this small amount of break time where you should be not having to perform the essential functions of your job. So it's not very burdensome in the end to comply with.
Yeah, let me just jump in here. Yeah, Sarah, can I jump in for a second? So one of the issues at stake in this litigation, and if you read the briefs that went to the Supreme Court, management is arguing that the sky is falling and that if they have to comply with these regulations, they'd have to add a flight attendant on every flight. It would have nationwide application and so forth. When you read the plaintiff's brief, you get a completely different picture. They say that it would be covering flights that are within the state of California, which is a fraction of the flying that these carriers do. A lot of those flights are not over, or they're not going to be over 4 hours. And I think generally speaking, the employers have resisted overtures, which would say there's a lot less burdensome ways to resolve this issue other than, the sky is falling scenarios. They could, work with the unions to get an exemption or an accommodation, rather, that would say, how are we going to do it in this industry? Which, if you look at the wage and hour statute, they have specific, provisions for about 10 different industries, or probably more, where they go through, if you're in this industry, the motion picture industry, this is how it works. This is how you get your breaks. So they have that option that they could do. There's also a provision that if you don't get the break, you could get a penalty. There's also discussion about, and I think the FAA said this in their brief, the Solicitor General, rather, about how rest can be taken in flight. We do in-flight rest all the time. Mm-hmm. So there's all kinds of accommodations you could reach. But I think it became clear to us in the course of this, and Sarah can speak to this maybe a bit more, but better than me, but it became pretty clear that when we reached out to them, that their real goal in this Bernstein case was not just to deal with this wage and hour issue, which there's easy fixes, right? Their goal is really to use this as a wedge issue to try and get rid of preemption overall. So then flight attendants wouldn't have protections on pandemic leave or sick leave or all these other progressive legislation which is being passed. And that would be a real shame if they were able to use this issue to kind of take away our basic rights.
Yes. Joe, I'm going to step back for just a moment and remind everyone that these are minimum standards. And so in some cases, we may have already negotiated meal and rest provisions in our contracts that might satisfy what this law is intended to do. So we just described the very specific, or John just described the very specific provisions about having a rest break after 5 hours. But we have negotiated in certain circumstances under our operational conditions, the requirement for management to board a meal. If we're unable to get off, if we're unable to have a rest break, to be able to go get that meal comes in on catering and it looks a certain way. We've been able to negotiate that. We haven't been able to negotiate that in every contract, though. And let me give you a scenario that is very, very difficult for some of the flight attendants doing regional flying. In some cases, they're the only flight attendant assigned to the flight because the plane is small enough that it only requires one flight attendant. They're flying potentially up and down in California throughout their entire day, sometimes 14-hour days, and they're serving drinks all day long because the service standards are just for drinks and maybe pretzels. And so there's nothing ever that's boarded onto the plane for the flight attendant to even purchase. In some cases, we've negotiated the ability to purchase meals on board, or the ability for the flight attendant to get off that plane to get any food. There's no place really to store the food. Their wages are at such that when they're staying in places where it's very difficult to get food that is at a decent price, that they're not able to properly plan for that trip. So there's some cases where flight attendants are working and they really are not able to get proper nutrition throughout the entire course of their day. These are the kind of scenarios that we want to make sure are not happening anywhere. And in many cases, many of the airlines and the practices that they have and the contractual provisions that they have may already satisfy what we're looking at trying to achieve here, which is simply to make sure that someone has the ability to eat, get proper nutrition, and has the time to do that without fear of any discipline. So these are very simple solutions. And as Joe said, it became very clear that really was not their goal, to solve the issue of the concerns around the California meal and rest break rule. Their goal was to use this as a wedge issue, to say, we're going to tell flight attendants that this is going to cause us to close bases in California, which on its face is pretty absurd. But to scare people into saying, well, wait a minute, I get food on the plane. I have time to take a rest. I have time to get food. I don't need this. Why would I want this aggravation? And to use an issue that would be so inflammatory, it's extremely inflammatory to talk about closing bases, to get people to say, wait a minute, I don't want this. And what they're trying to do is to inspire that kind of response so that they can argue for preemption everywhere. And we want to make that really clear. We want to address your questions. This has been communicated more at Alaska Airlines than any other airline. So I think we have a significant number of Alaska flight attendants on this town hall tonight. But we have flight attendants from across the industry. And this town hall is about ensuring those minimum standards for everyone. We want to make it very, very clear that we have made it clear to management that we're ready to work out this solution. I absolutely believe that if we came together with management to talk about the realities in the operation, and the FAA has suggested this as a solution as well, that we can come up with minimum standards and have a technical correction to the California meal and rest break law that we would go to the legislature together to put in place so that there's a minimum standard that ensures that our rights are upheld, but we're not disrupting the operation in a way that makes it difficult for the airlines to operate. So I have no doubt that in California, we would be able to get that through very quickly. And the airlines know that too. So I want you to know that they know that, the industry knows that across the board. And the message that they need to hear from flight attendants is talk to our union. The other point that I think is worth mentioning here is that many of these cases are brought forward by flight attendants who do not have union representation. This case was started when Virgin America flight attendants did not have union representation. There have been other cases in other states that have been brought forward by Delta flight attendants, also without union representation. And many, many, many times, the cases are brought forward without union representation because there's no other way for flight attendants to get results and to get protections in their workplace, but to try to enforce the law through these private class action suits. So our organizing efforts as well are really important in terms of making sure that we're growing power to be able to address the issues in our workplace and pushing back on every efforts of the airlines to try to undermine our rights. And so we want to get to your questions. And Guy, I'm going to ask you for a little help on that to see if we have any questions coming in during the course of this town hall. Can we get a status check on that?
At this time, we don't have any questions, but we haven't explained how to ask questions. So at the bottom of your screen, there should be a Q&A logo icon. You can click the Q&A icon and enter a question there. That would be the preferred method to ask questions.
Okay, great, Guy. And while we're doing that, I see that we do have a question coming in. So we'll see about this. What ground has been made in regard to exemptions, and what is AFA proposing in regard to exemptions? Okay, great. Thank you so much for the question. And I really appreciate that question because one of the things, and I'll have Joe and John back me up on this, one of the things that the court said in its decision that the law applies is that one of the remedies the airlines could seek is an exemption to the requirements of the law. Now, I want to be really clear. Not one of the airlines, this is more evidence that this is not really about the Bernstein case. It's not really about California Meal and Rest. It's about building an argument that we shouldn't have these rights anywhere. Not one of the airlines have availed themselves of the right to seek an exemption to the requirements of this law. And they do have that right. I think that the question, though, is coming a little bit from what Joe had said earlier about exemptions. One of the things that has been done in the past in California specifically, but in other states as well, is that unions and companies will approach the state together with a negotiated solution that is submitted to the state in the form of an exemption. Now, that may or may not be the route that we take here. It looks more like what we need to do in this situation is a technical correction together. So the industry on the whole, sort of negotiating with labor on the whole about how we would seek a technical correction to the law specific to the airline industry. But we can get to these solutions. There's a lot of ways to get to resolving the California meal and rest break issue specific to the operation of airlines if we simply talk. And that's, again, why I'm just going to say the message to management talk to my union is really important, because they should not be threatening flight attendants. It makes me very angry, actually, that they've got flight attendants worried about this, because there is no reason to worry. We negotiated with them over how to apply COVID relief, billions and billions of dollars, the entire industry at stake. The stakes were much higher there than they are around this issue. And we've shown that we can work together and come to solutions that even where management gives a little and we give a little, and we have a good solution together. And we can do that here as well. Okay, so I think that we have some more questions coming in.
Yeah, Sarah, can I jump in on that one real quick?
Oh, go ahead,
so
Joe.
I just want to go through it just so people really understand. And you can see this right in the California statute. There's special provisions that don't take away the right for meal and rest, but they talk about how do you accommodate meal and rest in that particular industry. And it's quite a long list. We got motor carriers, we've got the wholesale baking industry, we got the motion picture and broadcasting industry, we got construction, commercial driving, security officers, electrical corporations, and so forth. So you've got a wide variety of industry where labor and management get together and they say, hey, how we know maybe the particular provisions don't work for our industry, but we want to get adequate rest for the workers and our union members. And they come up with provisions and go and get the law corrected. So it has been done. It's not hard. It's very easy. We've reached out. Sarah wrote a letter to all of the airline CEOs and said, hey, let's actually fix this by sitting down. And that's really where it's at. And we believe that they should sit down with us and get this issue resolved.
Thanks, Joe.
And on top of that too, Joe, so building off what Joe was saying, the government also offered to help with this. And so at the Supreme Court, the government submitted a brief where the FAA actually offered to sit down with management and unions to try to work this out. And we've had crickets since then.
Yeah, we did have a specific question on this in approaching management. Have they refused to negotiate mediation or mediation? And so, as John just said, to date, that is what they have refused to do. So that doesn't mean that they can change their stance tomorrow, but all they need to do is talk with us. So I want to be very clear that up until the point that we wrote a letter and there was a response from the industry trade group overall, they were saying, oh yeah, we'd be willing to talk, but it was all verbal. We finally sent this letter because they were saying different things locally at specific airlines. They were saying different things about what AFA's stance was. So we wanted to be on the record as well. And once they came back with a response that said that they were not going to meet, that they were going to work this out through litigation. That was before the Supreme Court refused to take the case. So they're out of options legally at this point, and they really just need to talk to us. But so far, they have refused to do that. The next question, and I think Joe and John can handle this, do you think Alaska's concern about the rest meal break law being a risk on a national level is valid? John, I think
you say the last part? Go ahead, John.
They're asking, do you think that Alaska's concern about this being a risk on a national level is valid?
So I don't think that's valid. I mean, airlines have to comply with a variety of laws, like any corporation has to across the country when you are engaged in commerce in multiple states. I think what a lot of airlines do is they keep it simple and they just comply with the most beneficial law, and because that's going to work for everybody. So it's not like they have to actually comport with 50 different laws. They really, in effect, generally will just work with one. And airlines are already doing this. And so that's where we have sick leave statutes where not every airline has taken this aggressive approach that Alaska has taken, for instance. And you have airlines that are complying with some state laws. And it does show and reinforce this point that we're making, that it is not impossible to comply with different laws here. And airlines are already doing it.
Thank you. And then someone wanted to clarify, is this only for flights within California? If a flight leaves California for another state, then does this law apply?
So, go ahead, Joe.
Yeah, I mean, I think like I said before, if you look at the briefs, the parties are talking past each other because the plaintiffs, which would be Bernstein and the flight attendants, who brought the suit, make it clear to the Supreme Court that this is talking about cases that are within the state of California, which is a fraction of the flying. The employers, because their goal was really to paint this as being the biggest possible problem, wanted to make it about national flights and that it's covering nationwide flights. But that's clearly not what the parties bringing the lawsuit, are arguing it should be. And John, you can jump in and fill in too.
Yeah, no, you're absolutely right. Let's remember the Bernstein case. It involved Virgin, which was headquartered in California, received millions of dollars in tax breaks from California taxpayers. It involved California crews. It involved flying only within California. So it's like all these things that was clearly California specific.
We are getting, so I want to be clear, we're getting some questions that are very specific to specific carriers. Those specific questions we're going to get to your MEC to follow up and answer those, since this is an industry-wide town hall. So if your question is specific to your carrier, we'll get that to your MEC and you will get an answer. Okay, and then we have a question saying, what are some of the solutions that the union would bring to the table for this issue? I think that what we should do instead of, everyone's very familiar with this, we wouldn't want to show our negotiations card on a public forum. But what we can do is, John or Joe, can you just describe some of the solutions that the court even prescribed in this scenario, or some of the things that we have negotiated in the past?
So I think some of the issue of adequate in-flight rest and adequate opportunity to get meals is an issue that we have a long history of collective bargaining over. Certainly on our international flying and some domestic flying, we have opportunities for flight attendants to take in-flight rest and to get away. And one of the issues that was in dispute between the parties is the employers were making it out like you couldn't have a situation where in-flight rest could cover this. And I think the plaintiffs correctly argued that we have all kinds of situations where flight attendants take in-flight rest, and there's a provision in the law about if the employer is not able to provide it, that they give an hour of pay, and that there were provisions that they could do to resolve the issue. So we also, I think one of the things we bargain over is, if you've got a real busy day, maybe it's not long haul flying, but you've got a lot of legs, like Sarah was talking about some of these regional flying. We often try and get meals provided to the flight attendants, or we try and get time for flight attendants to be able to go off and get a meal if they're not getting meals provided. So there's all kinds of solutions we got a long history of bargaining over, and without laying out what specifics we would be seeking, there's easy solutions to all these problems.
Absolutely. Thanks, Joe. And then another question we have is there some deadline to try to accomplish some agreement with management? Are airlines being fined at the moment for non-compliance?
So that's an active litigation right now. So Bernstein is actually technically not over, even though the Supreme Court denied certiorari, so they didn't take the case. Now it is going back for further proceedings in the state to determine damages.
Right. We also have a question: if Alaska doesn't comply and decides to close bases, is AFA planning on legal intervention? And I just want to note, we do have Jeff Peterson, who is MEC president at Alaska, on here. I'm going to actually invite him in to partially answer this question. But this is, I want to be really clear that to close a base, that's a major, major financial implication for the airlines. So they have a serious disincentive to do that. And so if they don't comply and decide, to close bases over this and not come to the table, it's hard to imagine that they would do that just in order to stand up for the rest of the industry and their argument on preemption nationwide. So it's very hard to imagine that they wouldn't at some point decide to work with us here. The sooner, the better. And so I just want to invite Jeff in to see if he has any additional comments on that.
Well, thanks, Sarah. I can't speak to the legal intervention, but definitely we would push back as much as possible against base closure or any of the base closures in California. And just to assuage everyone's concerns, we truly believe that management is pushing a sky is falling scenario in order to get all of you to approach your legislators to ask for complete exemptions to state laws. And it's a for show. And we truly believe that Alaska is going to back off and that they will approach AFA and the legislature and all labor to work on some kind of technical corrections to the meal and rest law or other bargained fixes. So
Thank you,
see
Jeff.
that happening at this time.
Thank you. And I just can't say enough. We really believe that that's what they're going to do here. It's hard to imagine. Closing a base is serious, and there may be other financial considerations at an airline for closing a base, but closing a base over this issue, we find very, very hard to believe, because a viable base that is helping them make money, that's a part of their operational strategic plan, is something that is very valuable to them. And so there may be an assessment all the time about whether or not a base helps them with their profits and helps them with their operational need. And I'm not just talking about Alaska here. I'm talking about all airlines do this all the time. They assess these things all the time. But in isolation, the issue of California meal and rest and the way that the court has talked about this and the way that we think it applies, rather than in the sky is falling scenario where they're talking about it applying on a national level, on requiring augmented crews, on all these things that would make it very, very, very costly. We believe that all of those arguments are actually not really valid here. And all they have to do is sit down and talk with us. And we really need every flight attendant, instead of having management try to direct you to a place that's going to undermine your rights, to just simply say, talk to our union. Because we're not, and Jeff, I'm sure, can nod his head, the last thing we're going to do is allow management to close a base over this or any other ridiculous issue. We would fight like hell for any base to stay open if it's financially viable to do that. And even if it's not, then we would be fighting very hard to minimize the impact on flight attendants every single time. So this is a core issue for AFA that we fight around all the time. And we're just not going to let them do that over this issue. And so you can help us, and you can help us get to a resolution sooner by turning around instead and saying to management, talk to my union, get a solution, because the solution is right there in hand.
And Sarah, if I could just jump in real quick for one more item, that 3 of our 6 bases are in California. And just in looking at management's allegation that the supposition they can close the bases and that makes financial sense, it just doesn't pencil out. What are they going to do? They're not going to move flying outside of California. Where are the aircraft going to go? How are they going to get the crews into California to pick up the California flying? We can only speculate on where they would be talking about moving them, but whether it be, say, Arizona, Nevada, it just doesn't make sense financially. So, and that's just a quick back of the napkin look at it. So I just don't buy it.
That's right. We had another question about an understanding that regional flight attendants may suffer with this the most, about not being able to get that proper nutrition or the ability to take that rest. Sometimes the rest of us ask hitting crew members to help pick up meals for us. We all help each other and have each other's backs. The question is, how can we best support one another without feeling like a company target? And I want to just note, thank you so much for the spirit of that question and also what was behind it about looking out for each other and each other's needs. That is really the true spirit of the union, in having each other's backs, looking out for each other. And the best way that we can do that, I'll just say it once again, is just responding to management again. Talk to my union, resolve this issue. You have my union, you can talk to my union and resolve this issue, and you don't have to come at me about it. And that's a great response to them, a great thing to keep with you all the time, that you are not alone. As a represented flight attendant, you can always say that to management. Is there anyone else who wants to jump in on that, or shall I move on?
I think you covered it.
All right. Okay. And then we have another question. I think we sort of covered this before, but just to reiterate, are airlines subject to this law today, right now? What will the repercussions for airlines be since we aren't being provided the meal and rest breaks now? John, do you just want to recap what you kind of covered before?
Yeah, and I want to add one thing to it too. So at one point during the Bernstein litigation, the court actually said to Alaska, like, hey, you're on, like, maybe you have a reason to maybe not have known about this law before, although I don't think that's necessarily correct, but you're on notice now, and they still didn't comply. And so certainly from that moment on, they were on notice that they would be on the hook for any penalties for failure to comply with the state law. And that's what the court is determining right now.
Yeah, and I think one of the issues is California has what's called the Private Attorney General Act, where private individuals can sue to enforce the labor laws. And what that does is it really helps with enforcement, because if you don't have that in a lot of states, like how is it going to get enforced? You're relying on the state government, which it's not always the number one priority. So they have this law, and that law includes provisions that on top of the penalties for the violations, that they can also be assessed, certain fines or fees. I think it's John, correct me, but it's $100 per pay period per employee. But as John indicated, it doesn't kick in until a certain point. If an employer has a good faith belief that they're not covered by the law, it doesn't kick in. I think at a certain point in the Bernstein litigation, then the court has basically, put them on notice that they should be complying. And I think other employers who aren't complying should be concerned at that point. But there's an easy solution, right? You can avoid this by complying or by sitting down and talking with us and getting a solution. So people have asked some questions about when's the clock ticking and stuff. We think they should just sit down with us. The quicker, the better. And the longer they wait, the more the problem they're creating for themselves. So it really doesn't make sense.
If they're so concerned about this, in other words, everyone, the clock is really ticking right now on their exposure here under the law. And so if they're really concerned about how this is going to impact the airline, all the more important and urgent that they talk with AFA, and we work with other unions and we work on a solution here. Because as long as they keep this out there, they continue to be liable. They continue to be subject to that enforcement that Joe and John were just describing. So they're really being not very honest about their concerns around this, because if they truly were concerned about it, then they would be talking with us and seeking a resolution that will stem their liability. There is a question about so much misinformation told by management around this issue. What is AFA doing to combat this? And many flight attendants are quick to take what the employer tells them at face value. So we're holding this town hall. AFA Alaska, where a lot of the misinformation has been focused, has been doing communications almost daily on this. You can go to the afaalaska.org website and read all the back information from your union on this. We wanted to hold this town hall so that this information would be available to all flight attendants. We've had a communication on our website since early May around this for all flight attendants at AFA-CWA.org. We will continue to communicate there. And we would ask all of you who are on this call to help spread the word about And this will be an archived town hall that is available to anyone, so you can point people back to that. We'll have that up on the AFA-CWA.org website within 48 hours. And this information will be available. And, tell a friend, tell a phone, tell a flight attendant. We need your help to spread the word about what the correct information is. Okay. Let's see. Somebody says, when you tell management, talk to my union, would you suggest an email campaign? That is a good idea. We have been talking about that, and we believe that is actually the next step here. We had hoped that any way along the process here, they're going to pick up the phone. They have not yet. So we will be communicating more with members and asking members to take action. And we will have a coordinated Talk to My Union campaign that you can participate in. So it should be a general message that you're giving back to your specific airline, your specific management. But also we will have a coordinated campaign within the next week that everyone can participate in. Guy, am I missing anything that we still?
There's a question about whether there's a role for government to get involved in trying to assist us with resolving this issue.
Okay, so there is not a specific mediated role that the government has here, but the FAA has inserted themselves to say that they would be willing to mediate a resolution and has tried to talk with the parties about resolving this issue. So there's not a formal role necessarily, unless George on want to correct me, but there has been an effort by our government to try to help seek a resolution here. George on, do you want to add anything?
No, that's correct. I mean, they and I think John indicated before, they took the unusual step of adding it to their brief that they were willing to sit down and talk about how, rest could be accommodated in flights. That's the FAA. It was mentioned in the Solicitor General of the United States brief.
Okay.
So that they don't have a formal role in mediation or anything like that, but they could help us get together.
Great. And I'm going to ask another question that we have here. We may need to follow up on this one, but I'm just going to see if we're prepared to answer this. The city of San Francisco passed a free healthcare ordinance back in 1999 for employees working in the city. This past year, flight attendants and pilots were all of a sudden unfairly excluded because they're not ground workers. All other employees at airlines are still able to take advantage of this free healthcare option. Do we believe that this case sets a precedence for flight crews to regain this free option of healthcare in San Francisco?
So if it's the statute I'm thinking of, I'm familiar with it. And it is, so it doesn't apply to this because actually if you read the definitions of the provision, it actually explicitly excludes flight crews. And so that's why I think there's this carve out for the groups.
Okay, so in San Francisco, I believe that's right, John, and thank you for reminding me. But we would have to work on a technical correction to that San Francisco ordinance in order to have this apply to flight crews. And what happened was that the airlines enforced what was already there under the law, and we agree unfairly. Right. But that's what they used.
So, and just more generally, the whole area of preemption is very complicated. And, we get questions from time to time about the application of the law. And I think as the court has indicated in the Bernstein and the other cases, they make a separate analysis for each statute, whether or not that applies to the airline workers. And then they have to, consider what are the various grounds for preemptions that are being argued. And all of them are different. So, for example, sick leave programs under ERISA, that's a different set of analysis. So, I think we work with the AFA-MECs, when these issues come up. In some situations, we also tell flight attendants that you may want to contact your particular agency in your state, because sometimes that's going to be the best way to, get an answer to whether you're covered. But we're here to assist in any way.
Yeah, and that is something that I want to repeat. The good news here, and Joe is right, this is very complicated. And actually, Chris Black asked that question, brings up that even this can go down to the city level, not even just the state. So there's a lot of laws to keep up with, a lot of provisions to keep up with. And our union even if we're not experts in each individual ordinance, we can do that research. So I want to really encourage members, when you have questions out there and you're not sure, ask your union, and we can get those answers to you. That's part of the value of having a union. And where we need to fight, then we can fight as a union on those issues and organize around that and fight on improving those conditions. And finally, I would just say that an answer to management at all times is best. They try to deal with flight attendants directly all the time. They're not supposed to do that. We have the right to collective bargaining. That is our right as airline workers who are unionized, or as any workers who are unionized. We have that right to collectively bargain. And part of that right is that employers are not supposed to be engaging directly with employees to try to undermine that right. And that is really what's been going on here. And so we all need to take a little bit of offense at that, because this is really an attempt to try to undermine our right to collective bargaining in general. And collective bargaining is about solving problems. We can solve this problem too. I want to thank everyone for joining us here tonight. We'll scour over those questions once again. I think we got to everybody's questions that were here tonight. Well, we'll look over those again and make sure everybody gets answers. But thank you so much for joining us. Spread the word. We'll have, as I said, we'll have this as an archived town hall up on AFA-CWA.org within 48 hours, if not sooner. Stay tuned to communications. Look for that action within the next week about Talk to My Union. And I want to thank you so much for all of you engaging tonight. Have a good night. Have each other's backs, and feel the solidarity and love from your union.